A roster of Supreme Court decisions this week dominated headlines and spurred debate about affirmative action, discrimination in free speech, and student loan forgiveness. An opinion involving who has ultimate control over elections got far less attention, but does have major implications for the balance of power. And it is a case from North Carolina, but what could it mean for Florida? We take that question to this veteran of election law, J.C. Planas. So much fun to have you right here at the table with us.
Always. I think it's good afternoon now. It's not good morning.
Oh.
Good
you
afternoon.
Are absolutely right. Good afternoon. So take us through this opinion, which essentially says that state courts can now check state lawmakers in election law.
And all courts, really. And this is a precedent that's existed.
I mean, what was that
for
question
a while.
even? What was the question?
So what happened was, this was the third redistricting case they had. We had one in Alabama, we had one in Louisiana, and this was a North Carolina case. And it sort of bounced back and forth within the courts. But when it got to the U.S. Supreme Court, Republicans in North Carolina used what's called the independent state legislature theory. And all that is really is saying, we're the legislature, nobody can tell us what to do. The state courts can't review us, the federal courts can't review us. We have the power to do anything regarding elections because of something that's in the United States Code. So the way they were saying this was, even in, not just in the case of redistricting, saying they can't be reviewed by anyone, but in a presidential election, theoretically, they could have ignored the results of the elections in their state and given presidential electors to anyone they wanted.
Which right now in the news is something that
would have
might
been
be happening.
Chaos.
So redistricting, I mean, we have a very engaged, intelligent audience on this program. Everyone pretty much knows redistricting, and it just happened in Florida. So connect this, what could this case mean for Florida, where redistricting the latest maps is in the court right now?
Well, you have to combine it. Number one, this court says that, the redistricting map can be reviewed by the courts, this decision. But we also had decisions from the U.S. Supreme Court in Alabama and Louisiana where they struck down congressional maps that watered down African American and minority representation.
Which is the Voting Rights Act.
Exactly, and the interpretation of the Voting Rights Act saying you cannot draw a map that basically is going to take away voting power from pockets of minority communities. Well, in Florida, we had an African American congressional district in the north part of Florida.
District 5.
Al Lawson was the member of Congress that represented that area. And originally, the State House and the State Senate created a district that preserved Al Lawson. The governor vetoes it and basically tells the legislature, this is my map, approve it. Never in Florida history had a governor vetoed a congressional map. But there is a state constitutional amendment saying you can't bring in politics into redistricting. And that's where the problem is with that seat. And this case makes it very hard to keep our current maps.
So what happens practically speaking? Because reporting on the redistricting, it wasn't about politics and race, according to those who approved eventually the governor's maps. So now that it's in the court, that's for another court to decide whether or not to redo these. But practically speaking, we're all going to the polls in the not too distant future. We've already been to the poll. Those congressional maps in Florida are in place. Gave the Florida delegation a 20 Republican to 8 Democrat split. So those are already in effect. Practically speaking, what happens?
Well, the court is still looking at this case, the state court. There is probably like a 50-50 chance that they will finish it by the time of qualifying for Congress. We don't know. Courts can take their time. There could be now this case could move faster now because of this decision, and we could see changes before the 2024 election.
But those changes have to be done by the legislature.
Courts have drawn maps before. So there's been different cases of redistricting. Number one, where the court sends it back to the legislature and orders a special session. If the case moves now, we still have this session coming up in January of 2024. But
it's so close.
I know.
It just ended.
Yeah. But in many cases, the courts have drawn the maps themselves, and we've seen that. In the last redistricting in Florida, the Florida Supreme Court drew the congressional map.
And now the Florida Supreme Court
Is different.
Different.
It's a different political makeup than the last time. It has flipped politically. But again, now the U.S. Supreme Court is entitled to review decisions of state Supreme Courts.
You know what was so interesting? We were talking before the program, and that the decisions that came out of the Supreme Court this week are so politically charged and such debate and sucking up all the oxygen out of every newscast, especially nationally. 6-3 decisions, conservative, liberal decisions. This particular elections decision in Moore versus Harper, the North Carolina case, was a 6-3 decision, but not in a conservative way.
It was a very balanced way. We
Yeah.
had Kavanaugh, Amy Coney Barrett, and the Chief Justice Roberts voting with the 3 liberal members of the court, Sotomayor, Kagan, and Jackson.
And what does that say to you? To you as a former Republican who is now a Democrat?
I think, number one, the court is not going to give up its power. When you look at this North Carolina decision, and they cited even the most famous case that you learn the first week in law school, Marbury versus Madison, that shows that the courts can review, and in fact, even seniors in government classes know Marbury versus Madison, and it sets the precedent for courts reviewing decisions from the political branch. The court was not going to give up their power. They were going to say, we are the arbiters, we've been the arbiters since this decision, and we are going to continue to be the arbiters of these type of cases.
Why, here, one of the things that my mind asks weird questions while I read, and one of them was, why is this even a case when the Constitution has a balance of power between lawmakers and the judiciary, especially, and the executive branch? Why is it even a question whether courts can review laws?
It wasn't. And in fact, when they draft up the Constitution...
Is that elementary? Was that too elementary?
No. When they draft up the Constitution, there's the 3 equal branches of government, but it never mentions, just like the Constitution doesn't mention that a president can veto a bill, veto doesn't appear in the Constitution, the fact that the Supreme Court and the courts can review actions of the legislature and the legislative branch does not appear. So we have a common law system that we actually brought from England. A lot of things people don't realize. Some cases from old England are still good law in the United States.
You know, I'm thinking maybe we have a segment on This Week in South Florida. We bring professors in and kind of give us like a little lesson that day. That was really, it's very interesting, and you look very professorial today, Mr. Attorney. J.C. Planas, great to have you. I hope you'll be back.
Thank you.
To hold class.
Thank you very much.
Thank you very much.